Rule 4-1.7, conflicts of interest, current clients. It deals with the representation of two clients that are directly adverse with one another. A lawyer can't do that. If a lawyer is going to be substantially limited in what they do for one client as opposed to another, that's also a conflict of interest between two current clients. Notwithstanding that prohibition to doing that, a client may undertake that representation if a client is informed and makes an informed decision about it. The lawyer has to first come to the conclusion that he can provide competent and diligent representation to both clients. Then he has to give enough information to the client so they can make an informed decision about whether to consent to that dual representation. And then that consent has to be in writing. When does this problem arise? Well, a law firm has two big clients. They don't want to send one of those clients out to someone else for representation despite the fact they're directly adverse, because they're afraid that that other law firm, once they start doing work for them, they might lose the client. So what do? They try to say, oh, well, we can create a Chinese wall between our lawyers that are representing these two clients. Well, the rules don't allow that. There has to be an informed consent by both clients that they're going to allow that law firm or that lawyer to represent them and go forward in that representation. And the lawyer has to believe that he can give competent and diligent representation to both. Another interesting aspect of conflicts of interest between current clients is when a lawyer or law firm takes on the representation of multiple clients in the same issue. And the bar rules specifically deal with that, and they state that the lawyer has to give an explanation of the implications of that dual representation to those clients so they can make an informed decision. Has to advise them of the risk that they would potentially be exposed to and are exposed to in that dual representation.